Hey everybody, Bill Sack here, your favorite attorney with the Firearms Policy Coalition legal team. Last Wednesday, FFLs all over the state of Texas received a letter from the ATF about the recently enacted Texas HB 957. As many of you may have heard, the bill states that it exempts silencers made in Texas and which stay in Texas from federal regulation under the NFA. How does that work? Can they do that? And why don't more states have similar laws? Well, in this video, I'll do my best to give you the lay of the land. Back at the time of the framing of the Constitution, the founders were acutely aware of the necessity of restricting the power and reach of the federal government. The Constitution clearly establishes certain enumerated powers which are vested in the federal government, while other powers are granted to the states. One of the enumerated powers, known as the Commerce Clause, which appears as Article 1, Section 8, Clause 3 of the Constitution, is the justification upon which many federal regulations of the economy are based. The Commerce Clause gives the feds the power to regulate commerce, quote, between the several states, unquote, also known as interstate commerce, commerce that takes place between two or more states. A natural distinction can be drawn between such interstate conduct and intrastate conduct, conduct that takes place entirely in one state. Intrastate commerce, by its very definition, is not happening among the several states, so the feds can't touch it, right? Well, not exactly. Largely starting in 1937, with the change in time to save 9, a topic for another video, the Supreme Court started down a road of broader and broader interpretations of what kind of conduct would fall under the umbrella of the Federal Commerce Clause. The result being that the feds were given increasingly broad power to regulate every corner of the economy and goods that traveled within that economy. The definition got so broad, in fact, that in the 1942 case of Wickard v. Filburn, the Supreme Court ruled that even grain grown on a local farm and fed to the farmer's own cattle, grain that never left the farm, let alone traveled to another state, had a, quote, substantial effect on the interstate economy, and therefore could be regulated by the feds. Guns were no different. The constitutional hook that gave Congress the ability to regulate guns, so they claim, is that firearms travel in interstate commerce. The Supreme Court continued to broadly define interstate commerce for the next 50 years or so, until a 1995 case involving firearms marked a potential shift in the momentum, and a hint that the court was willing to start placing some boundaries on the Commerce Clause. In United States v. Lopez, the defendant challenged the constitutionality of the Gun-Free Zones Act of 1990. The defendant argued that the federal government had no authority to regulate guns in local schools, because guns in schools had nothing to do with interstate commerce. The government, with a straight face, argued that guns in schools was related to interstate commerce, because guns in schools could lead to violence, and violence in schools would have downstream economic effects that would eventually affect the national economy. Well, the Supreme Court wasn't buying it, and struck down the law on the grounds that the government's purported connection between the prohibited conduct, guns in schools, and interstate commerce was simply too attenuated. The court held that in order for conduct to fall within the Fed's power under the Commerce Clause, the conduct had to fall within the channels of commerce, like waterways, the instrumentalities of commerce, like railroads, or conduct that had a, quote, substantial effect on interstate commerce. So, with that legal context behind us, let's turn back to Texas HB 957 and the letter the ATF sent out a couple days ago in response. The Texas legislature is challenging the position that an economic product, in this case suppressors, which never cross state lines, can be regulated by the federal government under the guise of interstate commerce. The ATF's letter, circulated last week, cited the Supreme Court precedent that we just discussed and reminded Texas FFLs that when state law and federal law contradict one another, as they seemingly do here, that federal law wins and rules the day under another constitutional doctrine known as the Supremacy Clause. As of the filming of this video, I am unaware of any federal prosecutions against individuals or FFLs who bought or sold a local Texas suppressor without abiding by the associated federal regulations. If such a prosecution ever takes place, it could provide an interesting new vehicle to have the current lineup of Supreme Court weigh in and reconsider how broadly the Commerce Clause should be interpreted. Needless to say, this is an important issue that the FPC legal team will be following closely. You can stay up to date on this issue and all of the other cases we're involved in at fpclegal.org. I'm Bill Sack, your favorite attorney with the Firearms Policy Coalition legal team.